Did you know that Brazil is home to millions of international families, with cross-border relationships growing faster than ever before? Whether you are a foreigner married to a Brazilian living abroad with children back home, or a couple whose marriage spans multiple countries, navigating family law across borders can feel overwhelming and deeply personal. In this video, we will walk you through the most critical aspects of international family law in Brazil. We will cover international divorces, how foreign divorces are recognized under Brazilian law, child visitation rights across borders, and how child support is calculated and enforced in Brazilian courts. Understanding these legal frameworks is not just important, it is essential. Without proper knowledge, you risk losing rights, missing critical deadlines, or making costly mistakes that affect your family for years. Whether you are a foreigner or a Brazilian living abroad with family ties in Brazil, this video is your starting point. Now that we understand why this topic matters, let us look at how the Brazilian legal system actually handles family law cases. Brazilian family law is primarily governed by the Brazilian Civil Code, enacted in 2002, along with the federal constitution and specific legislation such as the Statute of the Child and Adolescent. Family law matters are handled by specialized family courts, known as Varas da Família, which operate at the state level across the country. When international elements are involved, such as foreign nationals, marriages abroad, or parties living in different countries, Brazilian law applies a distinct set of rules that go beyond standard domestic proceedings. These cases often intersect with international treaties, private international law principles, and procedural requirements that simply do not exist in purely domestic situations. This complexity is precisely why working with a qualified Brazilian attorney is absolutely essential. Without proper legal guidance, even straightforward cases can quickly become complicated, costly, and emotionally draining for everyone involved. Now that we understand how Brazilian family law operates, let's explore what actually qualifies as an international divorce in the Brazilian legal context. An international divorce in Brazil refers to any divorce proceeding where one or both spouses are foreign nationals, or where the marriage originally took place outside of Brazil. It also applies when the couple currently resides in different countries. What surprises many people is that Brazilian courts have full jurisdiction to process these divorces, even when one party lives completely outside of Brazil. You do not need both spouses physically present in Brazil to initiate proceedings. This means that a Brazilian citizen married to an American national, for example, can file for divorce directly through Brazilian courts, regardless of where either party currently resides. These are called direct divorce proceedings, and they are specifically designed to accommodate international couples navigating the complexities of cross-border relationships. Understanding this jurisdiction is the essential first step before moving forward with any international divorce process in Brazil. Now that we understand what an international divorce is, let's look at what's actually required to file one in Brazil. First, regarding residency, at least one spouse must be domiciled in Brazil, or why a marriage has been registered or performed in Brazil, so courts have jurisdiction over the case. In terms of documentation, you'll typically need a valid marriage certificate, proof of nationality or identity for both parties, proof of domicile, and any prenuptial agreements if applicable. Here's where things get procedurally important. If any of these documents were issued abroad, they cannot simply be submitted as is to a Brazilian court. Foreign documents must first be apostilled under the Hague Convention, or if the issuing country is not a signatory, they must go through full consular legalization. Additionally, all foreign language documents must be translated by a sworn public translator registered in Brazil. Given these layered requirements, having an experienced Brazilian family law attorney is not optional. It's essential for ensuring your filing is procedurally correct from the very beginning. Now that we understand the requirements, let's look at the types of divorce proceedings available for international couples in Brazil. There are two main paths: extrajudicial and judicial divorce. Extrajudicial divorce, processed through a notary office, is the simpler and faster option. It typically takes between 20 to 30 days to complete. However, it is only available when both parties fully agree on all terms and there are no minor children involved. This out-of-court route saves significant time and legal costs, although a lawyer representing the parties is a requirement. When disputes exist, terms cannot be agreed upon, or children are involved, judicial divorce becomes necessary. This court-based process is more complex and can take anywhere from several months to over a year, depending on the level of conflict and court workload. Choosing the right path depends entirely on your specific circumstances. A qualified Brazilian attorney can assess your situation and guide you toward the most appropriate and efficient proceeding for your case. Now that we have covered how divorces are processed in Brazil, let us talk about what happens when your divorce was granted in another country. Many people assume that a divorce finalized abroad is automatically valid in Brazil. That is not the case. A foreign divorce decree has no legal effect in Brazil until it goes through a formal recognition process known as Homologação de Sentença Estrangeira. This procedure is handled by the Superior Tribunal de Justiça, commonly referred to as the STJ, which is Brazil's highest court for non-constitutional matters. Without completing this process, your Brazilian civil records will still show you as married. This means you cannot legally remarry in Brazil, update your marital status on official documents, or enforce any divorce-related agreements, such as property division or spousal support, on Brazilian soil. The homologation process is therefore not optional. It is a necessary legal step for anyone whose divorce was granted outside of Brazil. Now that you understand why homologation matters, let's walk through exactly how the process works at the Superior Tribunal de Justiça. First, you'll need to gather your required documents. These include the original foreign divorce decree, an apostille or legalization confirming the document's authenticity, a certified translation completed by a sworn translator registered in Brazil, and proof that both parties were properly served or notified during the original foreign proceedings. Once your documents are ready, a Brazilian attorney files the homologation petition directly with the STJ. The other party is then formally notified and given an opportunity to respond. The STJ reviews whether the foreign decree meets Brazilian legal standards without re-examining the merits of the original case. The process typically takes between 3 months to over 1 year, depending on complexity and whether the other party contests it. After the STJ grants homologation, the decision must be registered with the appropriate civil registry office in Brazil, officially updating your marital status in Brazilian records. Even when you have a valid foreign divorce decree, getting it recognized in Brazil can hit unexpected roadblocks. The most common issue is a missing apostille. Without proper apostille certification, the STJ will simply reject your application. Next, translation errors matter enormously. Brazil requires certified translations by a sworn translator registered in Brazil, not just any bilingual professional. Incomplete or inaccurate translations will cause delays or outright refusals. Another frequent obstacle is failing to prove that the other spouse was properly notified during the original foreign proceedings. Brazilian law requires evidence of due process, meaning both parties must have had the opportunity to participate. Finally, some foreign divorce agreements contain clauses that conflict with Brazilian public policy, such as arrangements that violate children's rights or waive mandatory legal protections. To avoid these pitfalls, gather all documents early, verify apostille requirements for the specific country involved, hire a sworn Brazilian translator, and consult a qualified Brazilian attorney before submitting anything to the STJ. Moreover, because the filing through a lawyer is already a requirement. Now let's address some of the most common questions people have about international family law in Brazil. First, can a Brazilian court divorce a couple who married abroad? Yes, absolutely. Brazilian courts have jurisdiction to process divorces regardless of where the marriage took place, as long as at least one spouse resides in Brazil. What if one spouse refuses to participate in the proceedings? Brazilian courts can still move forward. The non-participating spouse is formally notified, and if they remain unresponsive, the court proceeds without them. Are prenuptial agreements made abroad valid in Brazil? Generally, yes, provided they don't violate Brazilian public policy and have been properly apostilled and translated. Regarding property division, Brazilian law applies the marital property regime as it could be considered established at the first domicile of the couple. If no regime was formally chosen, Brazilian courts typically default to partial community of property rules, dividing assets acquired during the marriage equally between both spouses. Continuing with frequently asked questions, let us address some important topics that often cause confusion in cross-border family matters. Foreign custody and support orders. These are not automatically enforceable in Brazil. They must go through the Superior Tribunal de Justiça homologation process before Brazilian authorities can act on them. Mistakes in cross-border family disputes can be extremely costly, both financially and emotionally. Do not wait until problems escalate before consulting an experienced Brazilian family law attorney. Now that we have covered international divorces and the recognition of foreign decrees, let us shift our focus to child visitation rights in the context of international families in Brazil. Brazilian family law is firmly grounded in one fundamental principle: the best interests of the child always prevail. This principle guides every judicial decision involving minors, regardless of the nationalities of the parents involved. Under Brazilian law, the default custody arrangement is guarda compartilhada, meaning shared custody. This means both parents retain equal legal responsibility for major decisions affecting the child's life, including education, healthcare, and travel. When one parent lives abroad or holds foreign nationality, shared custody does not automatically disappear. Brazilian courts will still seek to preserve meaningful participation from both parents whenever possible. However, the practical application of shared custody becomes significantly more complex in international family situations, requiring careful legal planning to protect the rights of both the child and each parent involved. When parents live in different countries, child visitation becomes significantly more complicated. Jurisdictional conflicts, language barriers, and differing legal systems can make enforcing visitation arrangements extremely difficult for all parties involved. Brazil is a signatory to the Hague Convention on the Civil Aspects of International Child Abduction, an international treaty designed to protect children from being wrongfully removed or retained across international borders. This means that if one parent unlawfully takes a child out of Brazil or refuses to return a child after an authorized visit abroad, the other parent can invoke the convention to seek the child's prompt return. Under this framework, Brazil's central authority coordinates with foreign authorities to locate children and facilitate their return. When a parent violates a Brazilian visitation order or removes a child without consent, legal remedies include emergency court injunctions, criminal complaints for international parental abduction, and formal requests through the Hague Convention's established international cooperation mechanisms. When a Brazilian court issues a visitation order and one parent lives abroad, enforcement becomes significantly more complex. Brazil cannot directly compel a foreign parent to comply, so legal cooperation between countries becomes essential. Treaties, bilateral agreements, and diplomatic channels are often required to give Brazilian orders any weight internationally. Conversely, foreign visitation orders are not automatically enforceable in Brazil. They must first go through the homologation process at the Superior Tribunal de Justiça before Brazilian authorities can act on them, but if there is an enforceable order already in place in Brazil, that ruling will prevail. If your visitation rights are being violated, act immediately. Document every violation and consult a qualified Brazilian family law attorney. Delays can seriously harm your case. Now that we have covered visitation rights and cross-border enforcement, let us turn to another critical topic for international families in Brazil, which is child support, legally referred to as alimentos under Brazilian law. When a Brazilian court determines child support, it does not apply a fixed formula or a simple percentage of income. Instead, judges conduct what is known as a needs and means analysis. This means the court carefully balances two sides of the equation, the financial needs of the child on one side and the financial capacity of the paying parent on the other. Several key factors guide this analysis. Courts examine the child's established standard of living, ongoing educational expenses such as school tuition and supplies, healthcare costs including medical treatments and insurance, and the income, assets, and overall financial situation of both parents. The goal is always to preserve the child's quality of life while remaining fair to the paying parent. To understand how Brazilian courts determine child support, let's walk through a concrete example. Unlike countries with fixed percentage formulas, Brazil gives judges significant discretion, meaning no two cases are identical. Imagine a father earning 10,000 reais monthly. After accounting for his fixed expenses, including rent, transportation, and personal necessities, his disposable income is approximately 6,000 reais. The child's documented needs, covering school tuition, healthcare, extracurricular activities, and daily living costs, total around 2,500 reais monthly. The court would then consider the mother's financial contribution and determine a proportional split. Given the father's stronger financial capacity, a judge might order him to cover roughly 60% of the child's expenses, resulting in approximately 1,500 reais monthly. This figure isn't arbitrary. It reflects careful judicial analysis of both parties' financial realities and the child's genuine needs. Documentation is absolutely essential throughout this entire process. Now that we have explored how child support amounts are calculated, let us turn to the critical question of what evidence is actually required to support a child support claim in Brazilian courts. In Brazil, child support cases are not decided on assumptions. Both the child's financial needs and the paying parent's capacity to contribute must be demonstrated through concrete documentation. Courts typically require pay stubs and employment contracts to verify the paying parent's income. Tax returns and bank statements are also essential, as they provide a broader picture of overall financial activity. On the child side, parents must present proof of actual expenses, including school tuition invoices, medical bills, therapy costs, and extracurricular activity fees. Importantly, Brazilian courts also consider lifestyle evidence. If a parent claims limited income but maintains an expensive lifestyle, judges may look at travel records, vehicle ownership, or property holdings as indicators of undisclosed financial capacity. When the paying parent lives abroad or holds income and assets in foreign countries, proving child support becomes significantly more complex. Brazilian courts face real difficulties accessing financial records held in other jurisdictions, especially when a parent deliberately obscures their wealth through offshore accounts or foreign business structures. When a parent claims to have no income, Brazilian judges are not simply required to accept that assertion. Courts can examine lifestyle evidence, travel patterns, property ownership, and social media activity to challenge such claims. The burden of demonstrating financial capacity shifts when circumstantial evidence contradicts a parent's stated poverty. Brazil utilizes international legal cooperation mechanisms, including letters rogatory and mutual legal assistance treaties, to request financial information from foreign governments and institutions. However, these processes are often slow and uncertain. This is precisely why thorough documentation from the very beginning of your case is essential. Gathering bank statements, tax filings, employment contracts, and asset records early dramatically strengthens your position before evidence disappears across borders. Child support orders in Brazil are not set in stone. When there is a significant change in circumstances, either party can request a modification. This might include a change in the child's needs, such as new medical or educational expenses, or a shift in the paying parent's financial situation, whether an increase or decrease in income. To request a modification, the requesting party must file a petition with the family court and present evidence supporting the change. This typically includes updated pay stubs, tax returns, bank statements, and documentation of the child's current expenses. When a parent fails to pay child support, Brazilian law provides strong enforcement mechanisms. Courts can garnish wages, freeze bank accounts, and restrict the debtor's passport. Most notably, Brazilian law allows for the arrest of a parent who willfully refuses to pay child support, making non-payment a serious legal matter with significant consequences. Throughout this video, we have covered the essential pillars of international family law in Brazil. From understanding what qualifies as an international divorce, to filing requirements, contested and uncontested proceedings, and the critical homologation process at the Superior Tribunal de Justiça, each step demands careful attention. We explored how foreign divorce decrees must be formally recognized in Brazil, the common pitfalls that derail recognition attempts, and how prenuptial agreements and property division are handled across borders. On the family side, we examined shared custody principles, the Hague Convention on Child Abduction, cross-border visitation enforcement, and how Brazilian courts calculate and enforce child support using a needs and means analysis. We also addressed modifying support orders and pursuing parents who hide assets abroad. The consistent message throughout is this: international family law cases in Brazil are deeply complex and highly fact-specific. Every situation is unique, and attempting to navigate these matters without an experienced Brazilian family law attorney can cost you dearly in time, money, and most importantly, your family's future. Brazil stands as one of the pioneering nations in formally recognizing and addressing parental alienation through legislation. Under Brazil's parental alienation law, known as Law No. 12-318, enacted in August 2010, parental alienation is explicitly considered an illicit act, a violation of the fundamental rights of the child and the non-custodial parent. The law defines parental alienation as any interference in the psychological development of a child or adolescent, promoted or induced by one parent, grandparents, or those who have the child under their authority, custody, or supervision, with the intent to cause the child to repudiate the other parent. Brazilian courts take this matter seriously, and judges are empowered to impose a range of sanctions against the alienating parent, including warnings, changes in custody arrangements, and in severe cases, the suspension of parental authority. This groundbreaking legal framework reflects Brazil's commitment to protecting the emotional well-being of children and ensuring that both parents maintain a healthy and meaningful relationship with their child, free from manipulation or psychological harm. When it comes to international family law matters in Brazil, Botinha and Cabral International Law Offices brings a level of specialization that sets them apart. This firm is specifically built to serve clients who are navigating the complex intersection of Brazilian law and international legal systems, meaning they understand not only the local procedural requirements, but also the cross-border dynamics that make these cases uniquely challenging. Whether you are a foreign national dealing with a divorce in Brazil, a parent fighting for custody across two countries, or someone seeking the recognition of a foreign court judgment, Botinha and Cabral has the expertise and the international perspective to guide you through every step. Their team is fluent in the legal and cultural nuances that often determine the success or failure of these cases, and they are committed to providing clear, strategic, and compassionate counsel to clients regardless of where in the world they are located. With a strong track record in international family law, Hague Convention cases, and cross-border asset disputes, Botinha and Cabral is not just a law firm, it is a dedicated partner for those who need experienced representation at the highest level. Reaching out to them early can make all the difference in protecting what matters most to you.